Yes, my lords. My lords, what I hope to do is first look at the textbooks, then I want to take your lordships through the Russian judgments, then I want to just briefly show your lordships the Russian law evidence, then I want to do grounds of impeachment, Zagloba and Russian state interference. That's going to be very short. And finally, why nothing turns on the standard of review.
Yeah.
That's my plan. I should just pick up one point in relation to earlier, which is, of course, the bankruptcy jurisdiction, insolvency jurisdiction generally, of course, gives rise to protection of the estate, relation back issues. And in this particular case, your lordships will be aware that after the events in question in 2015, Mr. Drelle came to England. I don't put it any higher than that, but it is another factor that, of course, the creditor will have in mind. Now, textbooks. Could I take you to Authorities 42, page 799, please? This is Dicey 14-12. And this is in...
Just out of interest, I know you say insolvency is special and different, because we sort of are, but what would your answer be in relation to a foreign arbitral award?
Well, it depends if it gives rise to a debt.
So you'd say the same would follow. I mean, it's you say this is all to do with the particular character of insolvency proceedings. It doesn't matter what type of debt, in inverted commas, or award or judgment or anything else that emanates from outside this court, our domestic court system. It's because insolvency is a particular regime with particular characteristics. It just has a different gateway to invoking the power of the UK courts.
Yes.
Have I got that right?
Yes, my lord, on behalf of creditors. However they become creditors, and as your lordship knows, and I've said before, ex debito justitiae, they are entitled to cause the debtor to enter into an insolvency process. And part of that process, and I did forget to mention this until just now, part of that process includes all the relation back provisions and the protection provisions. And that is different in that sense. And of course, it's fair to say that the only reason why you have protections of that sort is because it is collective, because it's not just for one individual, but for everybody. Anyway, may I move on to the textbooks, please? So 14.12, this is within Dicey on Rule 45, and 14.12 itself says, a judgment creditor seeking to enforce a foreign judgment in England, common law cannot do so by direct execution of the judgment. It must bring an action on the foreign judgment. And footnote 33, the judgment creditor may serve a statutory demand in terms of the foreign judgment, just as with any other unpaid debt, which is very much the point we've just been discussing. But if the validity of the debt is contested, the issue will have to be resolved as in an ordinary action to establish the enforceability of the judgment, and hence the existence as a matter of English law of the debt. And when it says as in, that doesn't mean you only go into court proceedings. Question is, if it is contested, question, is there a bona fide dispute? I can shorthand it. And if there is a bona fide dispute, then yes, of course, it goes into proceedings. If there is not a bona fide dispute, then the contest doesn't meet the requisite threshold, if I can put it that way. But what 45 acknowledges correctly is you can serve a statutory demand based upon a judgment, a foreign judgment. The other is Muir Hunter, which is in Authorities 44. And the first thing I wanted to show your lordships is actually on page 839, which is the editor's from the very start were Muir Hunter MH and JB is John Briggs. And the address is 3 Paper Buildings, which is the former address of South Square Chambers. The relevant part is your lordships have seen, and it is on page 842, and it says, in principle, a demand or petition based on a foreign judgment debt will be recognised for bankruptcy purposes without the need for specific registration, and it doesn't constitute enforcement, and it then picks up the cases. Now, my Lord Justice Snowden asked, when was that first sentence written and by whom? What I can say in answer is this. The whole paragraph, the entire paragraph, including the cases, we can trace back to October 2018. Mr. Hunter died in 2008. So the question is, was it just Mr. Briggs? I asked Mr. Briggs. And Mr. Briggs told me that he recalls writing the references to the cases. He cannot recall writing the first sentence himself. And he said, the fact that I cannot remember writing the first sentence makes me think it was written before, possibly on the basis of the registrar's practice, as they regularly consulted the chief registrar on practice and procedure. And he pointed out that Chief ICC Judge Burton was a consultant, and before that was James. I can't do better than that. What I can say, of course, is that Mr. Muir Hunter, and Mr. Briggs would have been aware of this, was the author of Williams and Muir Hunter. He was counsel in McGreevy. Both McGreevy and rear judgment debtor was cited in Williams and Muir Hunter. So that's as much as I can help with, and I'm sorry I can't take it further.
And just to be absolutely clear, when you say the whole paragraph, do you mean the
Yes.
whole of 3-316?
No.
Or do you mean the in principle?
In principle,
yes, I follow.
and the cases.
Yes, I follow.
And of course the addition of, I'm not including the reference to this case.
Yeah, quite. Yes.
So that was that. And then Briggs, which is in Authorities 38 at page 767 is the start. And it's 768. And it's actually the passage after the passage read by my learned friend, and it's the theory is illustrated by the practice. A successful litigant with a foreign judgment in his favour cannot enforce the judgment in England. No measures of execution will be taken on the strength of it. And the footnote 12, though they can use it for the purposes of a statutory demand leading to bankruptcy application if the liability is contested by the defendant, the entitlement of the judgment creditor to enforce the judgment will need to be established in English proceedings. Same point.
Sorry,
Oh, sorry, did I do that too fast?
You did it very fast, and I just haven't got that last bit. Where's that last bit?
I'm sorry, it's footnote 12, my lord. Footnote 12, my
Sorry,
lord.
yep, got it.
And the point that I would make, and it's picked up by Mr. Justice Richards in paragraph 53 of his judgment, is that in our submission, when it talks of having to establish it, the threshold is bona fide dispute. And then, of course, if there is a bona fide dispute, so you can't just say, I dispute this. There has to be a threshold, and the threshold would be, in an insolvency situation, would be the standard.
Well, this is where the case I mentioned this morning sort of potentially comes in, and perhaps in one sense assists you. I think, if I remember correctly, we held that if there's the question of whether there's a genuine and substantial dispute is really not about whether there's a debt. It doesn't determine whether there's a debt. It's really just the test for where the question of whether there is a debt or not is to be determined.
Absolutely. No, absolutely.
I mean, so you say it's a threshold. I mean,
what I mean by a threshold is if you get to bona fide dispute, it will go to ordinary proceedings. If you don't get to bona fide dispute, and the question whether or not you hit, I described it as a threshold, that will be dealt with in the insolvency proceedings. So,
but the question whether there's a debt, in a sense, is it's sort of. I mean, the mere fact that there's. Sorry. I'm just wondering how it actually works. I mean, because you'd say that there's a debt right from the very moment when
Yes.
the judgment is entered in Russia.
Yes. Yes. And then the question is that debt disputed? But we'd say bona fide and substantial.
But that's just a question of how would the English court determine whether there's a genuine substantial dispute.
Exactly. And that's where you get into what is described as a threshold test. You get into, can you bona fide dispute this debt? Or can you bona fide impeach it? Now, the reason why that's the test is, just imagine for a moment, come out of the insolvency court and you go straight into an action. You go into an action and you seek summary judgment or you go to a trial. What is the question the court is going to ask? It's going to ask, can I impeach this judgment? It's not going to go back and relitigate all the underlying merits. It's going to ask the question that you see posed by Rule 51 and question whether it falls into 52 to 55. Is this judgment impeachable? And I'm going to come back to the test for impeachable, but that's the question that would be determined in a trial on a question such as this. So the question when you're in the insolvency proceedings is there a bona fide dispute as to whether or not it's impeachable? What we say then, just drawing that together, because it does bring the end to one, is that a foreign judgment gives rise to a liability, which we would say is a debt due from the debtor to the creditor for the purposes of 267. It does not cease to be a debt just because it has not been registered or because it has not been sued upon. Whether or not there is a bona fide dispute about that judgment debt will turn upon whether it is bona fide disputed it can be impeached. And that is ground one. And what I would like to do, and forgive me if I sound as though I'm going very quickly, what I'd like to do now is take your lordships to the judgments.
Yeah.
And I brought this forward, partly because of the exchanges we had earlier.
Yeah.
So the judgments are in the supplemental bundle. And the judgments start in tab 12. I should just refer your lordships to what Mr. Justice Richards said. In fact, I'll just tell your lordships that it is paragraph 10. He summarises what I would describe as 3 key matters. And I think your lordships have seen it, and I won't read it to your lordships again, but it's a good starting point for when we turn to them. So, tab 12, C4, this is a ruling of the Arbitrage Court of the Yaroslav region. This is the first instance decision. And your lordships see at the top that the operative part of the ruling was announced on the 24th of April 2019, and this was then delivered a month later on the 24th of May. The judge was Judge Frolovicheva, and she then deals with the various people who were involved. There's just a couple that I want to point out. Having considered the court hearing application filed by the trustee in bankruptcy against, number 1, Mr. Drelle. Then there are some other shareholders. And then there is Alina Yurievna Ziglova. She was a defendant. There is then a description of the presence, who was present. So on the debtor's part, there is Isma Gulova. The representative of Mr. Drelle was Eliseva. And we will see this lawyer appearing in courts going further up, certainly for the full review, represented under power of attorney and so on. Then Gazprom Neft are represented by Avilkin. I'm not doing very well with the pronunciation. And that is something that they were entitled to do. So the one thing to completely disabuse yourselves of is that this was happening behind the scenes. They were entitled to appear, they appeared, and we've got their submissions recorded. And then on the founder's part, Zaglova represented under power of attorney.
What does that mean? I'm sure it doesn't matter, but on the founder's part, RTK, blah, blah, blah. And then Ms. Zaglova.
Yeah, no, we don't know. No. So if you don't mind, I'll just gloss over that for a moment. Then if we go to what you see on C4 through to C8 is the facts and the claim. Now let me summarise, if I can, the facts. So first of all, your lordships will see that the claim was originally 4.4 billion rubles, and then there were various other individuals who were joined and left. Having, at the bottom of it, examined the case materials, having heard explanations of the individuals present at the hearing, the court established the following. What you then get is that they concluded, so Mr. Drelle caused Servis-Terminal to conclude an agreement to lend 2 billion rubles at 8% until the 25th of May. There, Mr. Motilev was a surety. There were then various addenda which extended the time for the loan and reduced the interest rates. The loan was then assigned to Intercom Capital. There was, over the page, an addendum and surety agreement. And then you get to the 16th of February 2015, Servis-Terminal was wound up. And just so your lordships know, this money, the money that was being funded, was held by the company on behalf of Gazprom Neft in order to pay its customs liabilities. And what Mr. Drelle did was he took that money and lent it to Mr. Motilev and his companies. That I'm simplifying hugely. The debt was not repaid, and so on. So down at the bottom on C7, to substantiate the claims, the trustee in bankruptcy does the fact the actions of the former chief executive, Mr. Drelle, related to the provision of the loan in the amount of 2 billion to Fort Staten were not reasonable, nor good faith, and resulted in the company sustaining loss as real damage, and this is important, 788,000 as loss of profit. That claim was moving ahead of 788,000 loss profit was rejected. And then it's based on what is described as bad faith as not being in the interests of the legal entity. Specifically, he knowingly entered into the transaction under the terms and conditions which are unprofitable for the legal entity, with an entity who was known to be unable to perform its obligation to pay the loan, provision of the loan, and so on, not in the interests of. So it's a breach of fiduciary duty case, and your lordships can see the basis. Then if I can pick it up at the bottom of A13, it picks up the defence arguments. The representatives, Mr. Drelle and Mr. Glover, pointed out the loan has been provided in the company interest in order to earn profit, and so on. And that is picked up over, right to going over the page, and I won't take you through that detail. Having evaluated the arguments and the evidence provided for the inclusion into the case materials, the court finds the claim submitted by the trustee and bank is satisfied in part due to the following. Now, it then goes through the various legal provisions, and they are Article 32, Article 53. I'm not going to take you through them, but it's important that your lordship should see the judge analysed the various provisions, and then picking up at A14, according to paragraph 3 of Article 53, the person who by law or pursuant to constituent documents a legal entity acts on its behalf reasonably in good faith, benefit of the legal entity, and so on.
Sorry, where are you?
Oh, I'm sorry, bottom of C9. I mean, what I would say, my lord, is these judgments merit
Yes.
actually reading, but I'm just
Yes.
trying to give your lordships a flavour.
Yes.
The director has to act reasonably and in good faith for the benefit of the legal entity. And I'll just say now, the experts agreed that was the right test. But anyway, we'll look at that in a minute. And then further down, halfway down, there is a resolution number 62, paragraph 3 of unreasonableness is deemed proven when, without taking into consideration certain information, not taking actions about obtaining information. This is about repayability and reasonableness. And the reasoning, you then get the reason 2 paragraphs up from the bottom, pursuant to paragraph 1, resolution 62. Claimant insists the director is acting in bad faith and reason presents evidence confirming the legal entity suffers loss as a result of the actions. Such director may give explanations regarding his or her actions, name the reason for the losses. So it's setting out the legal provisions, and this carries on over the page. And I just want to pick up on C11 at the bottom. Your lordships see that Mr. Drelle could have and should have verified in advance the borrower's financial position, its solvency, should have evaluated all possible consequences, and so on. And then at the top of C12, conclusion of performance on the loan agreement, not good faith, reasonable performance. And that continues over the page. And if I can pick it up at C13, third paragraph down, based on the above provisions of Article 965 of the Arbitration Procedure Code, the Court makes the conclusion about the respondent's bad faith and unreasonable behaviour about the debtor having suffered loss of 2 billion rubles, about the existence of cause and effect connection between Mr. Drelle's behaviour and the loss suffered, which is confirmed in the materials of this case, and totality of conditions required for the application. And then further down, because the point was picked up, all other objections having related to the claims were considered by the court and dismissed as unsubstantiated, not supported by the evidence. Then claims by the trustee in bankruptcy seeking to recover damages in the amount of 788,000 in the form of market interest using the loan should be dismissed. The court takes into consideration the fact that Servis-Terminal was not a lending institution, as earning profit of this kind was not one of the company's activities. So that failed. And then picking up over the page on C14, you get to the ruling. Has ruled to satisfy the claiming part to recover from Mr. Drelle for the benefit of Servis-Terminal damages in the amount of 2 billion rubles. So that's the first judgment. And forgive me for doing this so quickly, but I need to. I then go over the page to C15. This is the judgment of the second arbitrage court of appeal.
Sorry, before you do so, C14.
Yes, my lord.
The relief
Yes.
it is an order for recovery and to issue a writ of execution. Is it?
After the ruling becomes effective.
Is it in fact the writ of execution that is being pursued here as creating the debt?
No, it's the debt, but I can tell your lordship that your lordship will see that the stay on the writ of execution goes by the end of this. So, whichever way.
Yes, but I'm just interested in whether we've actually got the piece of paper here that you say creates the debt, or whether it's actually the writ of execution which followed.
What? No, there isn't a separate order. There
is a writ of execution.
This is the judgment. Quite how they go about writ of execution in Russia, I don't know. Can I show you then the Arbitrage Court of Appeal? This is in August of 2019. There are 3 judges. The presiding judge is Shaklina. You then get 2 other judges and a secretary. The claimant's representative again is Eliseva. as you can see. Claimant, because he's appealing, they then consider the appeal, and if you pick up.
So just before we do,
Yeah.
so is Mr. Drelle represented here?
Pardon? It's Eliseva again.
Oh, I see.
Yes, he's
Well, that's intended by the claimant.
yeah, he's the claimant at this point. It's an appeal.
Oh, I see. So he's
I'm-
described
I
as.
would assume, but that is Eliseva. That is.
Yes, I see.
And then you get the representative of.
So Mr. Drelle is described as.
And
the
representative
claimant.
of Gazprom now.
Yep.
But the important point is it's the same
Yeah.
lawyer. I just wanted to pick up on C16. You then get the arguments of Mr. Drelle on C16. It starts, well, you've got Mr. Drelle did not agree with the ruling, filed appeal, seeking to cancel the ruling. And then you get his arguments. He points out the conclusions Mr. Drelle, before granting the ruling, did not verify contradicts the case materials, and he then goes through those arguments, and that records his arguments. Then at the top, that goes all the way to the top of C17, and then I want to pick it up. The debtor's trustee in bankruptcy is in his reply to appeal moving the court. So you then get the trustee's arguments down to the bottom of C17, where you get Gazprom Neft's arguments. And then over the page, onto C19, where you get the facts of the loans set out. And then on C20, 1, 2, 3, 4, 5 paragraphs down, the Court of First Instance, having examined the claims found them subject to satisfaction in part and awarded damages in the amount of 2 billion. That records the judgment. And then having examined the case materials, and this is how they do it, they do this here at first, studied the arguments set out in the appeal and replies to it, having heard representatives on the part, the Court of Appeal has come to the following conclusions. They then go through the law, and your lordships can see they go through that running all the way down C21 and over to C22, where they deal with unreasonable bad faith performance. And then 1, 2, 3, 4, your lordship, it's worth looking at things like this. Holding the chief executive officer of a legal entity liable depends on whether he/she acted when performing his/her responsibilities reasonably in good faith, i.e. whether he/she exercised due care and prudence and took all measures necessary for the proper performance of responsibilities. Then goes into resolution 62, and then if I can pick it up at the bottom of C22, case materials also confirm arguments of the trustee in bankruptcy regarding unreasonable bad faith performance of allegations by Mr. Drelle. The fact the loan agreement was concluded, and they then go through that. And they then, he had argued that it was verified, and so the case materials contain no evidence of any such verification. And picking up really at C23, the conclusion, bottom of the page, the above circumstances mean there were no reasons for considering Fort solvent and able to service its debt under the loan agreement. And then they go on, and there is a discussion and analysis. And I want to pick it up on C25, where picking it up at taking into account the above figures, the appellate court cannot consider as economically viable and reasonable the approval given by Mr. Drelle for the former chief executive officer of the debtor to the assignment of the debt. Therefore, taking into consideration all circumstances of the case, the Court of First Instance lawfully satisfied claims of the borrower's trustee in bankruptcy seeking recovery from Mr. Drelle damages in the amount of 2 billion. The judicial act in dispute was issued by the Court of First Instance with correct application of the rules of law, taking into account specific circumstances of the case. There were no reasons for cancelling it. The Court of Appeal did not establish any violation of the rules of procedural law that would result in unconditional cancellation, and then resolved. To uphold the ruling issued by the arbitrage court in the case and dismiss the appeal filed by Mr. Drelle, this resolution becomes effective on the date, and it points out that it can be appealed. And then if we go on to C27, it goes to the Court of Cassation. This is not a full review, unlike the previous appeal, which is, and I should have said that Professor Paul Stefan gave expert evidence that it was, as he described, a full review.
And was that accepted?
Well, I don't think anyone's challenged it, but anyway. Your Lordships can see what it is. I mean, at the end of the day, the best thing I can do is show your Lordships that was a full review. Whether or not the standard review is exactly the same as we do it in England or not, it's neither here nor there. It was a full review. We then get to the Cassation judgment, and this is then on the 6th of November 2019. And there are again 3 judges, and you will see that Mr. Drelle was represented again by Eliseva. It examined the Cassation appeal.
No relation to the chairman, presumably.
I don't know, but I don't know. But they examined the material, and I want, for this purpose, go straight forward to 33.
Sorry,
Sorry.
Just so I understand. Has examined the Cassation appeal.
Yes. Well, what?
No, I see. That is of Mr. Drelle.
Yes, and then, my lords, if you start at C28, just flicking over it through to C31, where it says examining the evidence submitted in the case file, evaluating it in accordance with the rules of Article 71, courts found as the date of the loan agreement with no fixed assets and so on and so forth. So it's not that they don't look at anything. You can see when you look through this that they go through it, and picking it up at C32, therefore, the courts lawfully considered that Mr. Drelle's actions as unfair and unreasonable, contrary to the interests of Servis-Terminal, not having preliminarily examined the counterparty's financial status and solvency issues and granting a loan in the amount of 2 billion, the acceptance of the surety to secure the loan, repayment transfer, and so on. In the above mentioned circumstances, the Lords lawfully considered Mr. Drelle guilt in damages caused to the debtor as a result of the loan, surety and debt transfer transactions and so on. The Cassation appeal applicant argues on incorrect appraising of judicial evidences on the case should be rejected, since evidence is relatively admissibility and reliability is solved by the court's first and appellate instances in each particular case, proceeding on the basis of case circumstances, and is part of the range of issues considering which does not belong to the court jurisdiction, considering the case in the order of Cassation proceedings, which I think is saying we aren't fully reviewing.
So no error of law, and the evidence was a matter for the lower court.
Yeah, thank you. And then the materials of the case examined by the court in first instances fully, and so on and so forth. And then they ruled. The ruling of the arbitration court of the 24th of May and the resolution of the second arbitration appeal court regarding the case to uphold the Cassation complaint without any further appeal, to annul the ruling of the court to suspend the execution. That's a point I made to your Lordship earlier. And the resolution and so on. And then the final one is the Supreme Court. And this was an application for leave to appeal to the Supreme Court. It's dealt with by a single judge. And I think I will take your Lordships straight to C35, where it says conclusions of the courts consistent with the rules of law, no reason for their reassessment. Courts do not. So he dismissed the application for leave to appeal to the Supreme Court. I apologise for doing it at such speed, but what your Lordships see is 2 judgments which consider the merits of the case by a single judge at first instance, 3 judges in the Court of Appeal, an appellate review by 3 judges, and an application for leave to appeal to the Supreme Court by a single judge. as Sir Michael Burton said in Maximov, which we will come on to, the fact that more than one court has considered a case is relevant to whether the decisions are deliberately wrong. And my learned friend's submission that if the first judgment is impeachable, the English court should ignore the decisions of the others is frankly incomprehensible. I'm sorry, it was incomprehensible. Can I then, the next thing I wanted to do was actually show your lordships, before I go to the grounds for impeachment, I actually want to show your lordships the Russian law material because it fits in neatly here. So the question, which I will make good to your lordships, is whether the Russian law evidence supports an argument that the judgment is either deliberately wrong, the judgments, I should say, but anyway, deliberately wrong, or so wrong as to be evidence of bias, or that no court acting in good faith could have arrived at it, or it is impeachable for fraud or opposed to natural justice. I've just encapsulated provisions I'm going to show you later. Can I, and what?
Sorry, just before you move on, I don't want to hold you up, but you're treating all four judgments in the same, as coming within the same category. Is there a distinction to be drawn between those which are a complete review and those which are only looking for errors of law? Because saying there's no error of law may not cure an impeachable defect if one has already occurred.
I understand the point your lordship is making. There are 2 points that we make. Number one, the material doesn't get close to establishing grounds for impeachment of the first judgment. And number two, there are no grounds for the subsequent judgments. I completely take your lordship's point that where you've got a full review, then it would be highly surprising, in particular the appeal court, 3 judges, full review, going through it all and having to establish those particular charges, if I can put it that way, against the court. That would be very surprising, and yes, to that extent I certainly do rely on that. And then one's got 3 judges in the Court de Cassation, and yes, they are only looking at the question of whether or not the rules have been properly applied, but
at the end of it, your case would turn on the first appeal, which you say was a full rehearing and
yes,
no evidence that those judges were in any
yes,
way partial or biased.
absolutely. And as far as the first instance goes, I'm now going to show your lordships the material, some of the material, just to show your lordships it didn't get close in relation to the first hearing, not even close. So and in our submission, Mr. Justice Richards and ICC Judge Burton were absolutely right that the Russian law evidence showed complaints against the judgment that didn't get close to what is described as the threshold test, and that was absolutely right. Can I show your lordships in the supplemental judgment, tab 11, B60? This is the joint report which my learned friend turned to very quickly of the Russian law experts. And I just want, without labouring the point, I want to show your lordships the left-hand column. Bear in mind that the areas of disagreement, rightly in our submission, have been said to be by ICC Judge Burton and by Mr. Justice Richards, and it doesn't matter on what threshold basis you want to apply. It doesn't matter. They've said these are just complaints. What I want to show you is the areas of agreement. So on issue 1, if you look at the left-hand column, the experts agree with the provisions of the application of the provisions of Russian law. And the experts agreed in 2 that the adverse consequences occurred for a legal entity during the period when a director occupied the position does not per se indicate his bad faith or unreasonableness. Over the page, 3, They agree on what would release liability for him. And then over the page 4, they agree that a director can be held personally accountable for the actions done in his capacity as a director in case of violation of the respective duties under Article 53, which your lordships have seen, albeit very quickly, is what the courts were looking at. 5, they agree corporate law provides for principle of the residual powers of director. Then in 6 is reasonability and good faith. And 7, they agreed as a general rule the amount of the loan had no legal relevance. The court can take this factor into account, as issuing a loan of significant value requires more caution. Then on 8, they were dealing with the question of it being a major transaction, and you can see the level of agreement. And then in 9, the experts agreed that a corporate approval of the transaction may be obtained before or subsequently. And as your lordships have seen, the courts considered that, and they said no. Then there was a question in 10 about commercial loans. 12 was they agreed that the courts weren't clear about the identity of the shareholders. So, issue 2 on B80, the experts agree on the basis of the petitioner's claim against the debtor and the amount sought. The experts agree on what defences were presented by Mr. Drelle with regard to the claim. The experts agree as to which grounds are set out in the court decisions. And issue 3, the experts agreed that the general length of corporate liability cases against Mr. Drelle was normal. So they agreed that it went on for a normal length. In 2, the experts agreed the court granted some of Mr. Drelle's motions, dismissed the claim for lost profits, and also dismissed some of GPN's motions. And then you get to causation, and I should just flick forward to issue 4, and your lordships might like to see what the experts agreed. The experts agree that the fact that the Russian state owns a participation interest in the charter capital of GPN does not imply in itself that there was political interference in the Russian proceedings. That's what the experts said about it. My learned friend's proposition, which I wrote down as being a case involving an entity owned by the Russian state, would be suspect, is not supported by the experts. The experts agree that political interference can be demonstrated or indicated by a non-exhaustive list of factors, such as cause, bias, position, egregious substantive or procedural irregularities. Experts agree it can be said the Russian courts are not immune from external political influence. And then duration, and we move on to issue 5, and that deals then with Mr. Motilev. And the point, and issue 6 on B96.
Sorry, I mean, issue 4, there was a lot of, they disagreed.
Yep.
As to whether there were any obvious or other indicators of political interference, etc., and there's quite a lot of difference.
Yes, and the point is, just because it's GPN isn't enough, and the whole thing then turns on if you look at our expert, important to look at that. No breaches in the hearing in the case of its merits, procedural irregularities occurred or insignificant. So yes, you can go through and say there are criticisms. The point that when they evaluated this, ICC Judge Burton and Richards, Justice Richards, both said these are of the nature of complaints. Sorry, I just wanted to show you issue 6, which is on 96, where the experts agree on the rights, degree of control and typical role of a creditor insolvency process, including participation in legal proceeding by a third party, which goes to GPN's point. And what I just wanted to show your lordships, I've shown your lordships two things. One is you've seen the judgments. These are considered judgments. They're considered judgments. They look at the facts. Now, can an expert come up with criticisms of them? Yes, of course he can. But look at the measure of agreement and ask yourself, do we get close to deliberately wrong? Do we get close to so wrong as to be evidence of bias? No court acting in good faith could arrive at it, impeachable for fraud, or opposed to natural justice? And the answer is no. And the ICC Judge Burton, who considered it carefully, was right about that, and so was Mr. Justice Richards. Which then brings me, I'm going back in my notes, I now want to look at the grounds for impeachment, if I may.
So we're leaving the supplemental bundle and going to the law? Or is that a misconception?
No, your lordship's absolutely right. Let's get the authorities bundle. So there are three grounds for impeachment of a foreign judgment: fraud, public policy and natural justice. The most important one in this case, given what's alleged, not what's happened, is fraud, which is Rule 53. And your lordships will find that in tab 42 at page 815, in which case it is said by Doyle, the judgment relied upon as such in proceedings in England is impeachable for fraud. Such fraud may be either fraud on the part of the party in whose favour the judgment was given, or fraud on the part of the court pronouncing the judgment. And your lordship will note it's referred to as Rule 50 in some of the authorities, but that's because the dicey rules have been renumbered. Can I then just look at, we go forward to page 820 just to pick up Rule 1441, 14141. The fraud which vitiates a judgment is generally be fraud of the party in whose favour the judgment obtained. It may, conceivably at any rate, be fraud on the part of the foreign court, as where a court gives judgment favourable because the judge is bribed, etc., etc. The important case to look at is Maximov, which is in Authorities Bundle 30. And this is the judgment of Sir Michael Burton, which your lordships have seen. Sir Michael Burton sitting as a High Court judge. And just to give your lordships the context, the claimant had won before the arbitrators, and the award was then overturned by a decision of the Russian court. The application that was being made was an application to enforce the arbitrator's award, and the application was made, we see it at the bottom of 546. The claimant said the Russian court's decisions were so extreme and incorrect as not to be open to a Russian court acting in good faith, so that bias could be inferred. So that was the application. And if your lordships look at the holdings, holding one is that the judge, and this is looking at the judgment to see whether or not it could be ignored and the arbitration could be enforced. And the first was the judge was clearly wrong in holding non-disclosure was not waivable. And then in holding two, this was the arbitrator's assessment of the price, and that was said to be an error of law. Again, the courts were wrong. And in holding three, the courts were wrong to find that the dispute was not limited to price and therefore not arbitrable. And I just wanted to read four. the claimant bore a heavy burden to establish not only that the foreign court's decisions were wrong or manifestly wrong, but they were so perverse that they could not have been arrived at in good faith or otherwise than by bias. Grounds 1 and 2 were dubious, and grounds 2 and 3 were unfairly not canvassed at first instance, but the decisions were not so extreme and perverse that they could only be ascribed to bias against the claimant. So that is the head note. And my lords, I think that I won't take your lordships through the individual criticisms, but what your lordships will see were that there was serious criticisms of the judgment in that case. And then the important passage is in paragraph 15 on 555. I have already indicated in paragraph 2 there's no issue between the parties that 1, the fact that a foreign court decision is manifestly wrong or is perverse is not sufficient. And it picks on OJSC, Bank of Moscow, and Erst Group. The decision must be so wrong as to be evidence of bias or be such that no court acting in good faith could have arrived at it. Secondly, the evidence or grounds must be cogent. So the evidence to support the decision being so wrong as to be evidence of bias or to be such the acting in good faith couldn't have arrived at it, it's got to be cogent. And that is important when we look at the evidence that there was in this case. Thirdly, that the decision of the foreign court must be deliberately wrong, not just wrong by incompetent. And that picks up the point really that goes to what my Lord Justice Snowden was just looking at. Yes, there are criticisms, but those criticisms are the sorts of criticisms that you might find against a judgment. The question is, was the judgment deliberately wrong? And we would say it wasn't wrong at all, especially when one looks at the evidence in the round.
I have some difficulty with the third of those. If one's looking at a case, which is not the case that Sir Michael Burton was looking at, but looking at a case where you're trying to divine whether there's evidence of bias from a range of different pieces of evidence, not solely from whether you can see from the face of the judgment that it's wrong.
Absolutely. As long as it's got to be cogent.
Quite. But deliberately wrong is not an element of the test that has to be fulfilled in all cases. If, for example, I'm asked to decide a case and I say the claimant is my brother and I'm not going to look at the evidence, I'm simply going to find in favour of my brother, that would be impeachable. Yes. Even if someone else were able to say, well, look at it, actually, the decision is entirely sustainable.
No, I see the point your lordship's making.
And the complaint against you, as I understand it, on the Russian law evidence, is that what happened was compartmentalisation, so that there wasn't an assessment of all the elements, including Miss Zhivoglev's, we've got the name, evidence, and that therefore both the judges went wrong in saying, in a compartmentalised way, I'll look at the Kulkov evidence. I've got to decide from that evidence that the judgment was deliberately wrong, and it just doesn't reach that threshold.
Yeah, no, but that's not what they did, because ICC Judge Burton, when she'd finished going through all of them individually, then looked at them collectively.
Right.
And she expressly said that that's what she was doing. And she expressly said that taking them together, it didn't get close.
Yeah, we'll come to that, but that's...
But that's the answer to your lordship's question.
I'm just alerting you, my concerns that Maximoff is not a complete test if one's looking at something which isn't confined to the face of the judgment itself.
My lord, what I can do is show your lordship the test. I can show your lordship where it's been accepted and applied. And if your lordship takes a different view, that's of course something your lordship can do.
But I'm sorry, I think you did accept that in a case in which one's not looking solely at the face of the judgment, subparagraph 3 was not
No,
a definitive statement of the test. I think you did accept that.
No,
Tell me if you
I
don't.
understand that, because if there's cogent evidence, then you're not just looking at the face of the judgment, you're getting evidence when you put it together, it's deliberately wrong. But what you can't do is rely upon...
No, my point to you is, when you put the evidence together, it may not establish that the judgment is deliberately wrong, but it may cogently give evidence of bias. But you don't accept that?
Well, no, if the judgment is correct, you've got to get to the judgment being wrong, because otherwise if the judgment is correct...
No, but the example I gave you
yes,
of my being biased,
you're being biased.
that
And you've got
might
to-
involve the judgment being right. It would still be impeachable, wouldn't it?
Well, I think one would have to look at it. But anyway, there
All
are
right.
2 minutes...
Well, I've canvassed it with you.
Well, no, I know.
No, I don't want to hold you up. I don't want to hold you up. I just wanted you to know that was in my mind,
But there's
so
no
you could deal with it.
We don't need to look at hypotheticals. We need to look at this case. And the fact is, on this case, is we've got the 3 elements which are said to show to hit the threshold test, which is what I'm dealing with now.
I mean, as I understand it, the threshold test isn't particularly in dispute. I
It's
have to
not
say,
disputed
otherwise,
at
I
all.
might have wondered whether it is right. I mean, why shouldn't these just be factors feeding into an assessment on the balance of probabilities? But
Anyway, I'm going to come on to that, because the threshold test in paragraph 61 was not disputed.
Yeah.
And that is important. And I really don't want to spend too much of my
No,
time
don't.
defending
I
something that
only thought it
isn't-
fair to raise it
But
to
yes.
see what you had to say about it.
No, I quite understand. So if I can, going forward to the conclusions in 53 on page 574, where he says, I refer to paragraph 15 above, which is his test. The claimant bears a heavy burden to establish not only that the foreign court's decisions were wrong or manifestly wrong, they are so perverse as for it to be concluded they could not have been arrived at in good faith or otherwise than by bias. Which of course is important if one's dealing with inferred bias, which is the point that was made earlier. This is more so in decisions were of 3 courts, and this is an important point from in this case, were of 3 courts, including the SAC, even if, as the claimant contends, the SAC simply shut its eyes to the obvious and avoided hearing a case which it would have to have overturned if acting honestly. There was plainly a difficult and uncomfortable decision for Judge Shumilina, whether or not she had first to make a decision as to whether constructive notice as well as actual notice would be sufficient. Seems to be she ducked the decision, fell back on an unsupportable conclusion that the non-disclosure would be waived. And then in 56 and 57, he goes through the judge's mistakes, and your lordships may have picked up that she relied upon 2 points that hadn't been argued. That wasn't enough. There was a flawed misunderstanding of what the factual case was. That wasn't enough. And then paragraph 60 deals with ground 3, 61 with 3 counter propositions, and then picking it up in 62, notwithstanding my severe criticism of and doubt about grounds 1 and 2, and the fact that grounds 2 and 3 were unfairly not canvassed at first instance, and had become almost writ in stone by the time they went up on appeal, I am unpersuaded that these decisions are so extreme and perverse that they can only be ascribed to bias against the claimant. I have considered, in the light of my conclusions about grounds 1 and 2, whether, albeit ground 3 may otherwise be arguable, it is tainted by the unarguability of the balance of the grounds, but I am similarly not so persuaded. Judge Shumilina did not let the fraud allegations as a basis for setting aside the award, which she could have done if she was determined to find against the claimant. She rested a shaky decision on which she was perhaps very uncertain as to ground 1 on a basis as to non-arbitrability that she knew was contrary to the decision of her fellow arbitrage judge 2 months earlier, but her judgment was a public judgment and it has not been regarded as an outlier or a one-off, but was regularly followed by later judges. The fact that such a harsh decision should have been made in respect of the work of these very distinguished arbitrators involving apparent conclusions about their lack of independence by virtue of their alleged subordination to their colleagues and leading to the somewhat extraordinary criticism of them by the FAC that they did not apply the imperative provisions of civil law on the calculation or of the purchase price, and even more so when determining the jurisdiction of the arbitral tribunal, the ICAC failed to examine the nature of the transaction, appears to me to be more indicative of the approach of the Russian court towards arbitration, to which I referred in paragraph 3 above. I do not, however, find that there is cogent evidence of bias against the plaintiff. And then, just going ahead, paragraph 71, you see the result. For the reasons I've given, I dismiss the claimant's application to enforce the award. So that was Maximov, and your lordships have seen the test. Thank you. And then, if I can show your lordships the Rosgostrak case, and I just want to, that's in tab 32, and this is the decision of the Honourable Mrs. Justice Mulder, and I just want, for present purposes, to show your lordships 98 and 99. And what she does in 98 is underline, and 99 she underlines passages from Sir Michael Burton's judgment, including the decision must be so wrong as to be evidence of bias, and those 3 points. So she underlined those, and in paragraph 103, she picks up a quote from Mr. Justice Cranston, where she says, it's not contrary to English public policy to refuse to recognise a judgment which is obviously wrong. And in 107, she applies the approach in Maximov, the decision of the KM Court must be so wrong as to be evidence of bias, to be such that no court acting in good faith could have arrived at it. And then going to paragraph 138, she then goes through, pulls the facts together in her conclusion. Firstly, the decision was plainly wrong. Secondly, there was evidence supporting the defendant's case of influence. It was a high-profile case because of the Superjet programme. And then in 5, as to the Moscow actions, the defendant's case is that the KM Court and the courts of Western Siberia were subject to potential influence in a way the Moscow courts were not. The initial judgments in the Moscow actions support the defendant's case that the courts in the KM May action could not properly have reached a substantive decision on the proper application of the law to the reinsurance policy. And she then concludes on this case, for the reasons discussed above, the claimant had not established that the defendant of bias had no real prospect of success, and it was a summary judgment application. And what we do get out of that is in the summary judgment context, which of course is the equivalent context, Mrs. Justice Mulder applied the equivalent to the threshold test applied by Mr. Justice Richards and ICC Burton. Can I just show your lordships the other grounds for impeachment? This is not going to take very long. If we can turn up tab 42 in Dicey, the first one is Rule 54. And that's on 823 of the bundle. And it is that a foreign judgment is impeachable on the ground that its enforcement, or as the case may be, recognition, be contrary to public policy. So that's the public policy ground. At first instance, it was advanced on the basis of alleged procedural breaches, but the answer is there were 4 hearings, as your lordships have seen. Your lordships have seen the 2 full reviews and then the review of what was done, so there is no basis for a public policy challenge.
Can I just ask one question, which I also know the answer to? Where does foreign revenue law fit into all this? Is in this collection of dicey rules?
What, as a separate rule? I
Well, is it a separate rule? I mean, suppose that this were a foreign tax authority coming here with a judgment it's obtained in its jurisdiction seeking to enforce it. Well, we wouldn't. But that's not a ground of impeachability. How does it work? It's a separate rule.
That's not a ground of impeachability, but that's a separate rule that we will not enforce foreign tax liabilities.
So just relating it briefly back to where we were, there's an issue. The foreign judgment presumably still gives rise to issue estoppels, yes, even in the revenue context.
Yeah.
But because there is a separate rule that we won't enforce foreign revenue laws, and you don't get into impeachability, you just say it's a foreign revenue law case.
Yeah, and well, it's interesting because this is public policy. And
that's what I was wondering. I wondered whether it would come into public policy.
I quite understand the point your lordship's making, and I have not picked up whether in any of these cases they are dealing with inland revenue as a basis of public policy. I haven't picked that up, but logically,
what is the rule that we don't enforce?
We don't enforce. As my understanding of the rule is, we don't enforce foreign revenue debts.
So can they prove in an insolvency?
I know you're asking me questions I just haven't thought about. I'm sorry.
I'd be surprised if they could, actually.
We'd be very surprised if they could.
Well, I would be surprised if they could, but I haven't considered that particular question.
Yeah, my follow-up question was
I'm
whether
very happy to go.
My follow-up question was going to be whether they can present a petition.
I don't think.
Or serve a statutory demand.
No, I don't think they could because.
My suspect is the answers to all those would be zero, no.
Yeah.
But I'm not sure the rule is expressed. Yes, that would be my follow-up. You know, is it because the rule is that you can't enforce, or that we don't recognise, or how is the rule expressed?
I can't answer that at the moment, but yeah, is that in the bundle? Sorry, I'm told it's under Rule 46.
Yeah, I can see that Rule 46 looks to be in point.
Sorry, where do you get that? 14 what? Okay. Oh, well, it's not in the bundle.
No, I can see that hasn't been thought to be necessary to be included.
Yes, no, well, we haven't been focusing on this point at all, and I'm sorry, but I haven't thought about it, and I certainly don't want to give inaccurate answers to your lordship's question. I'm very happy to go away and do a little piece on it if that would help.
Shall we see where we get to at the end of the afternoon?
Okay, of course we will. The other exception is Rule 55. And that's the natural justice exception. And whether or not there has been a breach of natural justice focuses on the regularity of the proceedings. And we know from Adams and Cape that it does not extend to mere procedural regularity on the part of the foreign court in accordance with its own rules. And where a procedural defect is apparent, he should use the local remedy before contending that the assessment of his liability was not in accordance with the principles of natural justice. And of course, again, I make the point that Mr. Drelle appealed all the way out. The next authority I should just deal with is another summary judgment case, which is at 29. Okay, it's the decision of Mr. Justice Cranston in OJSC Bank of Moscow, and it was a defence to a summary judgment application. You see that in 4, and in 5 it recaps the law through to 7, and in 8 it's looking at the natural justice point, and your lordships will see the propositions I have just made. A mere procedural defect in the proceedings will not be sufficient. And what, if I can go forward in 85 to 85, paragraph 85, there Mr. Justice Cranston held that there was no triable issue, that the appeal was conducted in violation of the principles of natural justice. In 88 to 89, there was no credible evidence of procedural unfairness. In 90, it's worth actually looking at this. So the attack on the judgment refusing the application for cassation identifies what are said to be the same flaws as the appellate judgment, and there is reliance on a particular provision, the omission to mention. For similar reasons those given above, I regard these as criticisms, and these criticisms as not arguable. So they're criticisms, but they are not arguable. And just going forward to 98, and you see the heading above 96 deals with fraud, and in 98 he says that the evidence goes nowhere near to being sufficiently cogent to justify a trial of the issues falling under this head. In my view, the duress argument has ballooned with time, now netting the bank in the alleged conspiracy, but as portrayed to me, the alleged conspiracy makes little, if any, commercial sense. And then he says in 99, there have been concerns about telephone justice in Russian courts, but even Dr. Gladyshev accepts that such instances of wrongful behaviour are atypical and states in his report that interference in this case might be plausible. Later he hardens up the criticism. And then in 100, in my view, none of this is arguable. Judicial impropriety can be inferred by an English court with departures from normal judicial practice, irrational conclusions, and so on, refers to OJSC. However, my reading of all the judgments is that they are straightforward and rational. There may have been mistakes in the reasoning, but there is nothing arguably untoward in their conclusion, that there was no defence to what were ordinary claims under guarantees given as security for the bank when it provided facilities. So those are the cases, and I just want to now turn to the threshold test. How am I doing? The threshold test. The first proposition, the starting point, is it is well established that a petition debt can be challenged for the purposes of presenting a petition if it is bona fide disputed on substantial grounds. And if I could pick up Mr. Justice Richard's paragraph 70, which you will find on A96, paragraph 70. In paragraph 69, he sets out the three propositions from paragraph 15 of Maximov, and he then says in paragraph 70 that the judge correctly had those principles in mind when she formulated the threshold test at 61. And as your lordships rightly note, that was not in dispute. But I'll just pick up the rest of the paragraph. Mr. Drelle argues that these principles do not determine how the judge was obliged to approach the allegation of actual bias or partiality. It was based on evidence of Mr. Glover. I agree. If, for example, a judge had received a bribe, that of itself would cause the judgment to be impeached, even if the judgment appeared otherwise to be impeccably reasoned and to come to the right answer. It's your lordship's point. However, the judge did not suggest...
And is it wrong?
No.
Did the judge get it wrong?
No. The first part of the formulation threshold test has Maximov correctly and properly in mind. However, the judge's formulation threshold test shows that there was a second aspect to it which could be satisfied by reference to Mr. Glover's evidence, namely, and there must be a substantial dispute, the judgment is impeachable by fraud proceedings reposed in natural justice. So we should then look at paragraph 61 of ICC Judge Burton's judgment. And that's on A50. It's called the threshold test because that was the definition that ICC Judge Burton gave to it at the end of paragraph 61. And she said this: however, the court must first determine the relevance of the areas of disagreement highlighted in the expert's report. Following Maximov, it is not enough to find that there is a genuine tribal issue, that the Russian courts appeared to have erred, or that a properly constituted tribunal would not have found Mr. Drelle to be liable. That is correct. Evidence to the standard of a general tribal issue of incompetence, if I were to find it, is not enough. That is correct. I must find that there is before me a substantial dispute as to whether the Russian judgments are deliberately wrong, or that the decision is so wrong as to be evidence of bias, or to be such that no court acting in good faith could have arrived at it, and or there must be a substantial dispute that the judgment is impeachable by fraud, or that the proceedings were opposed to natural justice. None of those propositions are wrong, and the other point that I think it's important for your lordships to note is that these are all alternatives.
Yes, so none of them are wrong. They would be wrong if they were regarded as individual requirements, but as long as you've got one of them, it isn't wrong to formulate them as alternatives. That's what you're saying.
No, she's formulated, said either.
And does the earlier part, in fact, add anything to the last bit? Must be substantial dispute, the judgment's impeachable by fraud, or proceedings were opposed to natural justice. I mean, that's the test, isn't it? What's gone before are simply factors which might indicate that test is fulfilled.
My lord, I don't want to try and excise anything from her the threshold test, particularly as it's not disputed. But I understand the point that your lordships.
Well, it's important. It may be important in the context of this case, because if either the ICC judge or Mr. Justice Richards was looking only at some of those earlier elements in isolation, that would have been an error of approach, wouldn't it?
Well, they weren't. So
no, but that's why I'm saying it may be important.
Well, I understand the point that your lordship's making.
Yep. I mean, as Mr. Justice Richards said, ultimately it's the bit at the end that matters.
Yes.
Yep.
Yeah. I'm not disagreeing. But as I said, it's not challenged, and it's consistent with the summary judgment cases in OJSC and PJSC, Track. It's consistent with those. So, having established that test, we then need to turn to the material. I took your lordships to the Russian judgment and the evidence of the legal experts. I've done that already, and I did it then because it seemed to me that was actually probably a better way around. So, that leaves me two other things to deal with, which is Zaglova and Russian state interference. So let's start with Zaglova. The foundation of Mr. Drelle's appeal relating to Zaglova is that she gave evidence, quotes, that the proceedings before the Russian arbitrage court had been predetermined against Mr. Drelle. Her evidence does not say that. It is what Mr. Drelle wants it to say, and if Miss Zaglova, who, as your lordships have seen, was the finance officer and one of the defendants, could have said it. She would have, but she didn't. The evidence was not rejected. It simply does not bear the weight my learned friend wants to put upon it. Now, ICC Judge Burton did not accept that the evidence was inadmissible because it was double hearsay. That was a submission that I had made that was wrong, and before Miss Justice Richards, that was made clear. But she didn't accept.
Sorry, just so I understand.
Yeah.
It was made clear before Miss Justice Richards. Was it a live submission before the ICC judge?
It was a point that I made in passing in reply. And it's one of those points that you think is terribly clever when you're on your feet in reply. And I subsequently thought, once my learned friend became involved, and they were making the point that it was all ringing in her ears, which it just wasn't. And I realised that had been wrong. But I failed. I mean, the point about it not being admissible is I was wrong. And if you look at 131, she describes it as hearsay, not because she's ruling on it as inadmissible, but because she's making the correct point, which is that because it's double hearsay, it's not very cogent.
Right. Back to the 131, 117 debate.
No, I know. But there are 2 points here. One is, was it admissible? Answer, yes. 2, was it cogent? Answer, no. Why isn't it cogent? Is it only because it's double hearsay? No. Because you can look at the analysis of what she actually said. And we'll look at that. So if we go to the supplementary bundle at A10, sorry. Yes, it's in divider 3, and we can pick it up. Your lordships have seen, you've seen this, so I won't go through it entirely, but paragraph 61 is where she starts dealing with the meeting with Miss Lobanova. And it's regarding the chairman of the court.
Sorry, I must be in the wrong place. Which page are you on?
A19.
Oh, I see this. Yeah.
I'm so sorry.
Yep.
There's a heading, meeting with Ms. Lobanova regarding
Yes.
chairman of the court. You then get 73, in which she states in terms that it's her personal view and her professional experience. So this is a matter of opinion, and of course she is a finance officer. And we then get to what she actually said. So, paragraph 79, in January 2019, I called Miss Lobanova on her mobile. They agreed to meet. We agreed I'd travel and we could meet on the 26th of January. Paragraph 80, Miss Lobanova and I met on the same day at a cafe which was located near the venue. She was at a conference. Paragraph 81. Now, Miss Zaglova explains to Miss Lobanova that the situation, namely Mr. Drelle had received a claim from ST's receiver, who was really representing GPN, for 4.4 billion rubles. So that's what we are told Miss Zaglova said to Miss Lobanova. I asked her if she can contact Mr. Khrushchev and find out who is really behind this claim. So the question that she was asking was, who's really behind this claim? And the reason she explains is they were very confused because they thought they were working with GPN towards the same goal, i.e. recovery from Mr. Motilev, who was the gentleman who had received the money, who's also now a bankrupt. Paragraph 82, Lobanova says she should go and make a few calls and let me know what she finds out. So she leaves and Zaglover is waiting. And then she returns after an hour. And then you get this. I understand. So she doesn't say, she told me she had spoken to Mr. Gusho. I understand she spoke.
Just pausing there.
Yeah.
You're not going to suggest that that is evidence that she was told that there had been a conversation between...
I don't need to. But what I'm doing is, I'm just showing you what it says, because you've now got two judges, ICC Judge Burton and Miss Justice Richards, who have both concluded that this, even taken with everything else, is not cogent evidence.
Keep going. Ignore my facial expressions.
Lobanova says things do not look well from Mr. Drelle. She said GPN is pushing this claim forward. Fine. Given that GPN was behind the claim, and then you get Zaglover's understanding, which is understood to mean a very influential, powerful company working closely with the highest levels of the Russian state. Incidentally, I don't know if you've picked up, but whilst Gazprom is 95% owned by the Russian state, Gazprom has a stake of 50.3% or whatever it is of GPN. Just a fact. Your Lordship may not have picked up. We cannot win this case. She said that the decision would be judgment against Mr. Drelle for $2 billion. And of course, your Lordships will bear in mind that this evidence is given on the 26th of February 2021, which is after judgment had been given for $2 billion.
You would say that, but that sounds like a cross-examination point of itself.
No, I don't need cross-examination.
No, well, I see that, but in that case, the aside doesn't help.
Look, the straight on was he had caused the company to loan 2 billion rubles. It's hardly surprising that anyone should be saying, this doesn't look good, he's going down for 2 billion rubles.
When the claim was for 4.4 billion.
The claim was for 4.4, which indicates that the suggestions that GPN means that 100% you're going to win is simply wrong, because they didn't. The claim was reduced from 4.4. Actually, I haven't checked when it was reduced, but it was reduced from the 4.4 to the 2.788.
At some stage.
You know? No. Okay, sorry. It had been reduced to the 2.7888, and they didn't succeed on the 7.788.
Yeah.
And the point that has been made, and made by Mr. Justice Richards, and I respectfully submit is right, the statement, we cannot win this case, does not mean it was predetermined. Doesn't mean that. And it doesn't matter whether it is Guschev or Lobanova or Zaglover's view, the statement, we cannot win this case, does not mean this case has been predetermined.
What else does it mean? Given that GPN was behind the claim, we cannot win this case. That's what she was told, that Guschev had told
That still
Lobanova.
doesn't mean it's predetermined.
What else does it mean?
Predetermined.
What else does it mean? Given that GPN is behind the claim, we can't win this case, and the decision will be judgment against Mr. Drelle for 2 billion.
Yeah, well, it was a very strong case for the reasons that you've seen, and it's hardly surprising that Ms. Zaglover should have recorded that. It's hardly surprising. Remember, she was a defendant in the case.
Well, that might be so if it was nothing to do with GPN being behind the claim, but that wasn't what she was being told.
It was not the only reason, but the critical point, and this is the point that Mr. Justice Richards concluded on, and also ICC Judge Barber, this is not cogent evidence that it had been predetermined. It doesn't say that. and your lordship can come up with a different construction to that of ICC Judge Barton, different evaluation, because this is evaluated from Barton and Richards, but it doesn't say that.
And just pausing there for a moment in terms of what the approach should be. If you have a trial as to whether or not a judgment should be recognised, we're told in Maximov that you need cogent evidence to succeed. We're not at the trial stage. So presumably you don't necessarily need cogent evidence, you need reason to think there could be cogent evidence.
No, you have to, exactly, you have to be satisfied that on bona fide and substantial grounds that
There has
it's
to be
arguable that
a
there
triable
is
issue
cogent evidence.
as to
Yes.
whether or not.
Whether or not there's cogent evidence. And the answer to that is no. Whether you take it together or separately. You've got
Because you say take this at its highest, take it at face value at its highest.
Absolutely.
It couldn't amount to cogent evidence.
No, exactly,
If
my
this
lord.
is what she said in the witness box, at the contested trial, the court couldn't treat that as sufficient
That
cogent
is-
evidence. That's essentially
Yes.
your submission.
No, it is. It is, my lord. Because what you've got is you've got the finance officer of the company talking to some friend who's an accountant who says that she'd spoken to someone who wasn't sitting on the case who said, look, but didn't say this has been predetermined.
The trouble with they're not sitting on the case bit is
Yeah.
paragraph 73.
Well, her opinion that this is her personal view and given her professional experience, she's an accountant.
And I'm
But not contradicted, I think we were told, by Mr. Egeroff or Mr. Locke. Not Mr. Locke, whoever his counterpart was. Have I got that right? Or?
Well, we'll have a look at that. But really,
Anyway, the judge treated it as something that he should
yeah,
take at face value. And
yes.
treat as unchallenged.
Look, we can take all of this at face value. Yeah. But then the question that I'm answering is it cogent? Is it cogent?
well, you're not asking that question. You're asking whether there's a tribal issue as to whether, at a trial, there could be cogent evidence.
Well, the answer to that is no, because it's based on this. This is let's get real for a moment. Your lordships have seen the underlying claims and ask yourselves, is this cogent evidence that the first instance decision was predetermined? And then ask yourselves, how does that sit with a full review on appeal? How does that sit with the Court of Cassation looking at it? Is that all predetermined? They looked at it again. Oh, sorry, I overheard comments. So one's got to look at this as a whole. One's got to look at Zaglova's evidence in the context of this is her, we know she is, talking to a counsel mate who tells her, I've made some calls and I've spoken to the chairman of the court, and because and she doesn't say it's predetermined. Just imagine that it said it's predetermined. Just imagine that she said this has been predetermined. 90 of the merits, you're going to lose because it's predetermined. It goes on appeal. There is absolutely no suggestion that that appeal was in any way tainted by any fraud at that stage. And there's nothing then in relation to the Court of Cassation. I accept it's not a full review. And the Supreme Court judge looks at it and he says, no, this all looks, I'm not giving you leave to appeal. Well, that's all. One's got to ask, is this cogent evidence of fraud in this case against all those facts? And in our submission, it just isn't. So, oh, thank you. So my team are reminding me every time we hit half an hour.
Very wise.
And so your lordships have seen Sir Michael Burton's test. We've debated that. And the important point is neither ICC Judge Burton nor Mr. Justice Richards rejected this evidence. They didn't reject it. They evaluated it and concluded it was not sufficiently cogent. And if I can just take your lordship to a couple of paragraphs, because I haven't looked at the judgment enough, but I'm taking that almost as read. Paragraph 87
of Mr. Justice Richard.
Justice Richard. So it's
87, do you say?
87, my lord, yes. Sorry. I just want to pick up a couple of things that he said about Sir Glover. So he deals with the in paragraph 87, he deals with the manifestly incredible point. So he says, in oral submissions, Mr. Samick argued that provided Mr. Glover's evidence was not manifestly incredible, it was sufficient to establish a triable issue that the judgment was impeachable for fraud. I do not accept that. To be cogent, Mr. Glover's evidence needed to point in favour of the proposition that the arbitrage court had made up its mind in advance to decide the case in favour of GPM. In other words, pre-decided. I consider that the judge was entitled to conclude it did not do so. While I quite accept the lack of cogency did not follow inevitably from the fact that the evidence was double hearsay, there were material gaps in the evidence that flowed from the fact that Mr. Glover was reporting on a conversation that Miss Lobanova had with Mr. Guzchev. The judge was not obliged to fill those gaps in a manner favourable to Mr. Drelle. In particular, 1, there is no attempt to report either what Mr. Lobanova actually said to Mr. Glover or what Mr. Guzchev actually said to Miss Lobanova. What is relayed is simply the gist of both conversations. 2, it is not clear whether the statement that we cannot win this case is something Mr. Guzchev said or whether it was simply Miss Lobanova's opinion on the matter. 3, Mr. Drelle argues that it is obvious that the view of Mr. Drelle could not win was that of Mr. Guzchev, not least because since paragraph 85 of Mr. Zaglover refers to the negative outcome which Mr. Guzchev had described to Ms. Lobanova. I do not agree. Ms. Lobanova's brief, as described in paragraph 81, was to find out who was really behind the claim. It is quite possible to read Mr. Glover's witness statement as meaning that the negative outcome was that GPN, who Mr. Drelle had previously been assuming was focusing on tracking down assets owned by Mr. Motilev, was in fact focusing on securing a contribution from Mr. Drelle to ST's bankruptcy. If Mr. Guzchev was simply confirming that GPM was behind the claim against Mr. Drelle, it is quite possible that the view that Mr. Drelle cannot win represented the opinion of Mr. Glover and or Miss Lobanova rather than a statement of Mr. Guzchev. Moreover, the wording in paragraph 83 of Mr. Glover's witness statement reads most naturally as an expression of Miss Lobanova's opinion. The words "she said" appear at the beginning of the second sentence and of the fourth sentence. Therefore, the conclusion that there would be a judgment against Mr. Drelle for $2 billion is expressly said to be a statement made by Miss Lobanova rather than by Mr. Guzchev. One might expect that if Miss Zaglova was intending to make the eye-catching assertion that the chairman of the court had told Miss Lobanova that Mr. Drelle cannot win, that would have been said expressly. Mr. Luff, at paragraph 70 of his report, appears to have read her witness statement in this way, referring to the conclusion allegedly drawn by Miss Lobanova after her telephone inquiries with Mr. Guzchev, which I think picks up the point the Lordship was making.
And I see force in what is said. I mean, this of course is on appeal rather than what District Judge, ICC Judge Burton said. But just coming back to the point about the test, if you're concerned with whether there might be cogent evidence at a trial, what is the significance of saying, well, things haven't yet been said? I could read such and such this way, not the other way. I mean, it sort of sounds as though these are things that you might anticipate could be filled in. Miss Justice Richard says the judge was not obliged to fill in the gaps. Yeah. Well, I mean, doesn't he have to ask himself whether the gaps might be filled in?
No, because Miss Zaglova was putting in a witness statement expressly intended to challenge this bankruptcy petition. That's what it was there for. If she could have said those things, she would have said them. And in circumstances where she does not say them, then the court is entitled to question whether or not that brings it to the standard of cogency. an ICC Judge Burton and Ms. Justice Richards say no, and they're entitled to do that because they're entitled to say, well, I've got some evidence here that says imagine getting a car crash or something. I've got some evidence here that says they saw Mr. Jones getting in the car, and then they say that they saw the car hit the woman, but they don't say, I saw Mr. Jones driving the car to hit the woman. If the question is, was Mr. Jones still driving the car, the court is entitled to ask, is this cogent evidence? It was Mr. Jones driving the car that hit the woman. And that is why gaps in evidence like this matter. And we can't just assume that if only we could get Ms. Zaglova to come over for a trial, we'd get better evidence. That's not. I would respectfully submit that's not what this court should be doing. The court should be asking, is this cogent evidence? No. And that was an evaluative process because ICC Judge Burton in the first instance, and then Mr. Justice Richards second time round, they are evaluating that evidence against the test.
Can I just ask you this?
Sorry.
What are we concerned with? Plainly, Mr. Justice Richards was concerned with the correctness or otherwise of ICC Judge Burton's decision. Now we see that Mr. Justice Richards has expressed views himself. Are they of any significance, or is the question whether ICC Judge Burton's decision can be impugned?
I would say both. Both Mr. Justice Richards and now you are entitled to review what the previous court has done. When it comes to an evaluative assessment of the evidence, the one that matters is ICC Judge Burton. Do you agree? Sorry, I just thought I'd check before I get into big trouble. But I think that must be right.
So you say, well, there was an evaluative decision by ICC Judge Burton, and various principles apply when you consider a challenge to an evaluative decision.
Yeah.
And I follow that. We don't have to worry separately about an evaluative decision by Mr. Justice Richards. The question is whether he was right to interfere with ICC Judge Burton's decision on the principles we've talked about.
And what it shows is that he made an analysis which demonstrates that which she was right when she said this isn't cogent because there are further reasons, if I can put it that way. But it's the first instance evaluation that matters, because sitting in this court in an insolvency matter, we are in the equivalent of the Supreme Court, in that the first instance decision is the ICC, second decision is an appeal, and this is the final appeal. So in one sense, we're in the equivalent of the Supreme Court. You don't
It matters.
I'm not sure.
But why is it the final appeal? I can't.
It is a final appeal. There's no appeal on an insolvency matter beyond the Court of Appeal. This is final.
Is that really right?
What? Yes.
But where did we find that?
Well,
You just thought we ought to know that.
Where is it? No. What?
That's not right.
Is it not right?
I mean, we'd like all our decisions to be final, but I'm not sure why this one would be.
Fantastic. If you can find it, it'd be great.
Oh, I've been assuring the client that this will be the end of it. Well, that's awful, especially with no disrespect, especially my learned friend on the other side. Well, okay. I will withdraw that until I establish otherwise. That's quite surprising. Okay, doesn't matter. Can I just, because
I was reliably informed by a member of the Supreme Court earlier this week that they were hearing an appeal in an insolvency case. So,
yeah, but was it a case that had been to the ICC judge first?
who knows?
No,
I'm not sure why that makes a problem.
Well, it's because that's a first instance hearing, and the
No,
appeal.
the restrictions on appeal are only on whether there's a second appeal, which you have to have special grounds for to come here, and this is a second appeal. But
Yes.
I don't think there's any further restriction or limitation other than the normal ones of the Supreme Court.
Well, the Supreme Court would be interesting to see. I'd be amazed if that was an ICC judge finding originally. But anyway, we're wasting.
I'd like to believe it won't be relevant, Mr. Phillips.
Yes. Well, I'm sorry that I'm prematurely elevating you all. Can I just deal with Luff and Russian state interference, because I'm conscious of time.
Yep.
So the first point is that given the agreement of the experts of Russian law that applied to Mr. Drelle's case, the evidence of state interference is of little significance. And what the evidence of state interference showed was that there could be cases, usually against opponents of the regime, where there was evidence of state interference. But this is not such a case. As for GPN, your lordships have seen the comments of the legal experts. It does not give rise to an irrebuttable presumption that they would win. And as your lordships know, in this case, Servis-Terminal was only partially successful, both in terms of quantum, we lost the 788,000, and in terms of defendants, there were defendants against whom we did not succeed. And also, and this is, it is in the legal expert agreed report that I showed you, Servis-Terminal lost a number of motions. If I can take you to Mr. Justice Richards at paragraph 115, where he makes the same point that was made by ICC Judge Burton in 115, is Mr. Loft's evidence was not focused on the judgment or the proceedings that led to it. Rather, it was, as Sir Michael Burton noted in connection with similar evidence advanced in Maximov, evidence of context. I do not accept the submission that Mr. Bickford-Smith made in his oral argument that Mr. Loft's evidence was probative of the appellant's case. Mr. Loft's evidence was of the wider political and societal context in which Russian judgments are given. It was certainly capable of supporting Mr. Drelle's case, since it suggested that judges in Russia might exercise partiality in favour of GPN. However, the judge was entitled to conclude that his evidence was insufficient on its own to establish a triable issue, since it said nothing about how the particular proceedings against Mr. Drelle have been conducted. I do not therefore agree that 131 represented the outcome of a mini trial and so on. And I think, what's the paragraph in which she said taking it all together? Sorry, I just can your lordships go back to A66 in ICC Judge Burton's judgment? You've seen 117, which is in relation to Zaglova, but it's 118, where she says this: I have addressed each of the alleged procedural defects separately and found that none gives rise to a substantial dispute that there was a breach of natural justice. Is this, however, a case in which there are so many alleged breaches that while none may overcome the evidential hurdle in isolation, cumulatively become close to meet the threshold test? The answer in my judgment is firm no. First, it's relevant to notice Mr. Drelle did not raise his complaints in Russian proceedings. Secondly, and then it deals with the appeals. And 131 you have seen.
So that's a view cumulatively, but only of those that are within heading 9, the procedural irregularities. It's not a,
and then
not a step back looking at everything.
Yeah, but 131 is that.
Yes.
Where she says the most I've seen is a keen interest by GPN's chief executive officer to pursue Mr. Drelle via criminal proceedings. Anecdotal evidence of Russian courts would be highly reluctant against GPN. This is where she pulls it together in relation to the fraud. So she does it in relation to procedure, she does it in relation to to the fraud, and to the end of 131, she says that it's insufficient to lead me to conclude there's a substantial dispute that the proceedings giving rise to the debt in this case were tainted by political interference or bias. So she pulls all of those factors together.
Where in that paragraph does she take account of Mr. Kulkov's criticism?
Sorry?
She's here now under heading number 10, state influence and partial proceedings.
Yes.
You say this is where she takes everything into account. Where does she take into account Mr. Kulkov's points here?
She doesn't do that there, but if you go on to return to the relevant test,
right?
So she then goes to the relevant test. If you pick it up at 136, none of the complaints raised by Mr. Kulkov amounted to more than that complaints. And then she says, I didn't. So Mr. Davenport submitted that if I see enough to realise that is coming, i.e. that the judgment arose as a result of miscarriage of justice, I must stop because such concerns would be investigated in Part 7 proceedings. Using his words, I did not see enough to make me stop. I saw Mr. Drelle, having successfully procured that ST received payment for several loans, unfortunately encounter a difficult outcome in relation to the loan. So what she then says in 137, she says, Mr. Davenport said, when you're going through this, if you get to the point where you think there's enough, you should stop. And she says, no. She then goes on to say she saw the various appeals. And then in 138, beyond the hearsay evidence of Mr. Glover, alleging the chairman of the court disclosed to a third party the outcome of Judge Frolicheva's first instance judgment before its release, two very serious but nevertheless anecdotal concerns at the importance of GPN losing a substantial amount of money in ST's insolvency, and that the state of interest of GPN would lead all and any judge to know that life would become difficult for them if they were to hold against GPN-funded liquidator. I have simply seen no evidence to lead me to conclude that there is a genuinely arguable case that the three judges sitting in the Second Arbitrage Court of Appeal, the chairman and two judges sitting in the Cassation Court, a single judge sitting in the Supreme Court, approached the case in a partial manner. Judge Frolicheva ruled against ST in relation to several motions. Fraud and collusion are by their nature hidden, but even the low threshold test requiring the debt is subject to a substantial dispute requires more than was before the court in these proceedings. What she does, and she doesn't do it in a single paragraph, my lord, she looks at each of them, then she goes to the should I stop question, and she pulls all of them together in those various paragraphs.
Well, she doesn't really. 138 is a bit odd because it concludes, it's beyond 1 and 2. I haven't seen any evidence to lead me to conclude that the appeal judgments are impeachable.
Yes, and
it's all directed at the appeal judgments.
Absolutely, but
and yet what is in 1 wasn't directed to the appeal judgments. It was directed to the first instance judgment, and neither in 1 nor 2 does she take into account the Kulkov points.
Yeah, but what your lordship is
to say she's drawing it all together here.
She does. I'm sorry, your lordship is being unfair. It's not just in that paragraph. It's first of all in 118 that I showed to your lordship, and then in 131, and then when she 137 and 138. What she's doing is cumulatively, she is looking at the various parts, and I think it's, if I may respectfully put it, it's unfair to the ICC judge to think that she did not stand back and look at it as a whole. Sorry. Yeah, well, and it's pointed out to me. If one looks at 131, where she talks about a relatively small number of procedural breaches, a potentially harsh application with the benefit of hindsight of the law surrounding directors' duties, hearsay, anecdotal evidence, and general recognition some cases in Russia are affected by bias are insufficient to lead me to conclude there is a substantial dispute the proceedings were tainted by political interference or bias. Those are legal issues. But she has taken them into account. And what she's done is she's taken the various different aspects into account in different parts of her judgment. So we see in the same paragraph you have the reference to hearsay evidence, which as we know is Glover. And so I would respectfully submit it's unfair to the judge not to take, because 118 you can see viewing the alleged breaches cumulatively, then 131, then Mr. Davenport, stop if you think there's something wrong, and then beyond, which is 138. So I would respectfully submit, my lord, it's not fair not to look at all of them. Now, sorry. Yes. In relation to standard of review, with respect, it doesn't matter because there were the evidence this doesn't turn on the standard of review. Mr. Justice Richards didn't say, I am finding this against Mr. Drelle because I am bound to take what ICC Judge Burton has said, giving it great weight or whatever. ICC Judge Burton evaluated it against the threshold test. She was right to do so. And I'm sorry for your note, I'm looking at the time. You'll see that in 78, 79, 120, 121.
Sorry, Paris 78, 79.
120, 121.
120.
Just so that you can see that is. So, yeah, and the point that I was going to make is none of his conclusions depended on the standard of review. So yep. It's a bit of a red herring. Two other things. First of all, the respondent's notice. Your Lordships have seen what we said about them. I know I probably shouldn't say this, but I don't think we need them. But if your Lordships do you need them? Well, you've got them. And then with the last minute, let me just say this. ICC Judge Burton was right. There is no bona fide dispute in relation to the debt, if I can call it that, the liability arising out of this judgment. We do not need to have registered the judgment. We do not need to have an English law judgment for the purposes of a petition in bankruptcy. Mr. Justice Richards was right when he reviewed the decision of ICC Judge Burton, and this appeal should be dismissed. Mr. Drelle lent 2 billion rubles of money that was held by Servis-Terminal, and it was held by Servis-Terminal in order to discharge the claims for customs of its customers. He then agreed to extend the loans, he agreed to reduce the interest rates, and the loan was never repaid, and the Russian courts concluded that he took inadequate steps in order to ascertain whether Mr. Motilev, the guarantor, and the debtor were going to be able to repay the debt, which of course he did not do. And that was upheld on appeal, went to Court of Cassation, it went to the single judge in the Supreme Court. And standing back, that is not a claim that is unfamiliar to English eyes. It is a breach of fiduciary duty claim which English lawyers can understand. So the judgment was plainly not obviously wrong, but even that wouldn't be enough. The evidence of bias or fraud is not cogent, and in our submission it gives rise to a debt that is immediately due to the petitioner. and there has never been any suggestion that Mr. Drelle could pay it. That's for sure. So in our submission, there is no bona fide substantial dispute. The judgment is impeachable. This is the third court to consider that question, and in our submission, it follows the bankruptcy order was rightly made. My lords, 4 o'clock. I'm sorry to have taken that at such a fast pace. I'm sorry. I don't know if there are any further questions, my lords.
Okay, can I just pick up the earlier point about foreign revenue, and I'll just put it out there whilst we've got you on your feet. The rule in Dicey is that direct or indirect enforcement of a foreign revenue statute is not permitted by the English courts. It says the English courts have no jurisdiction to entertain an action for the enforcement directly or indirectly of a revenue law. Now, the actual case that is best suggested for that is an insolvency case, actually. It's Government of India and Taylor.
Oh, yes, of course.
Which, where the House of Lords said that the Indian government could not prove in a winding up for its revenue claim. And the best basis that it was suggested for that is that it would be the extension of the sovereign power of a foreign state, which imposes the taxes, and the assertion of sovereign authority by one state within the territory of another, as distinct from a patrimonial claim by a foreign sovereign, is contrary to all concepts of independent sovereignties, which is perhaps where a lot of this debate started.
Yes.
So it seems to be a public policy that we don't allow foreign sovereigns to exercise their power here, and we don't assist them directly or indirectly, including in an insolvency context. The only rider to that is that things changed in the cross-border insolvency regulations in 2006. And I'll just put it out there, because Article 13 says, under the heading Access of Foreign Creditors to a Proceeding under British Insolvency Law, but subject to paragraph 2, foreign creditors have the same rights regarding the commencement of and participation in a proceeding under British insolvency law as creditors in Great Britain. Now, Celia Millman seems to regard that as really just saying you can't discriminate against foreign creditors. But there's then a sub-rule which modifies the Government of India and Taylor rule and does allow foreign revenue claims to be admitted, or at least not challenged, save to the extent they are a penalty or on any other ground that a claim might be rejected. So I've just said it all simply because it may or may not give rise to some further consideration that people might want to give as to whether any of that is either relevant or worthy of some submissions. But that's the authority about foreign revenue laws, which is an insolvency authority.
Yes, no, of course.
I suspect that the last word on that is the Supreme Court in Scat, the Danish tax case, which was specifically considering enforcement of claims by the Danish tax authority to recover fraudulently pursued withholding tax applications, which were held not to fall within the policy rule against enforcement of foreign revenue. But I can't now remember the extent to which there was an exploration of the underlying rationale for the rule, but I'd be surprised if there weren't.
Just, I might say that Lord Justice Popplewell and I are sitting on a case involving just that consideration next week.
Well, I am certainly not going to get into some, especially when your lordships are considering it next week. But
I should say we're
considering a different point, but in the same case. We're not considering that point at all.
Issue of estoppel and abuse.
I see. But my immediate response is that revenue claims, and I'm sorry I forgot Government of India and Taylor, but my immediate response would be that there are a number of specifically specifically revenue related rules flying around, and I would suggest that we should be reluctant to import any of those into what we're considering here, which is a breach of fiduciary duty claim, breach of director's fiduciary duty claim. But if you would like further research and thought to go into that, we will of course give it.
Let's hear Mr. Samek and then just see where we get to. Mr. Samek.
Firstly, on the last point, we say that the cross-border insolvency regulations don't impact this particular case or the legal issue, the subject of ground one. In relation to the point that Lord Justice Snowden mentioned, Dicey Rule 20, which was of course Dicey Rule 3, that was referred to by me in the extract of Professor Briggs's article from the LQR, just to remind your lordships, at Authorities Bundle 38, if you want to look at that briefly, AB tab 38.
Just before we spend time doing things, how long are you going to take? Because I think we need to finish by 12:30.
Oh, well, I'm hoping I'll be pretty swift.
Oh, well, that's all right.
Yeah, I mean,
if you've got time to look at it, by all means do.
Yeah, no, I'm pretty confident I'll be done by 12:30.
Yes.
I hope I won't have to ask your lordship's indulgence for 30 seconds, but I'm pretty...
So you would like us to look at the LQR?
Well, I just remind you, it's not going to take very long. So if your lordships could kindly go to 38, and at page 768, I showed the Lords this passage because your lordships see, this is the penultimate paragraph on the page 768, beginning now if, and it's the point about state sovereignty. Common law draws two conclusions completely effective within the territory. I read that to your lordships. And then the fundamental rule of the English common law has always been an English court's no jurisdiction to enforce a foreign penal revenue, what's sometimes described as other public law. There's now a general agreement that Dicey's Rule 3, which is what that reflects, and is now Dicey Rule 20, is a particular manifestation of a more fundamental rule, that an assertion of exercise of the sovereign right of a foreign state won't be enforced by an English court. Follows that in the absence of legislation, foreign judgment can't be enforced in England. And Lords, also, in that regard, in Authorities Bundle tab 20, I showed your lordships yesterday the decision of Judge Pelling, QC, sitting as a High Court judge in the Morris case. That was the importation of cigarettes. And your lordships recall there was a claim made by Belgian customs. And what this led to, of course, was a petition presented against Morris, not by Belgian customs, but by HMRC. And his lordship, at page 326, paragraph 4, refers to what he calls the legal landscape. At common law, a claim by or on behalf of a foreign state to recover taxes due under its laws is not enforceable by proceedings before the English court. There's the Government of India reference. However, that rule has been abrogated by European Community law in relation to certain taxes and duties owed by a taxpayer resident in one country, and so on and so forth. And then that gave rise to the directive, and it was in relation to the regulations then made under the directive and the reference to a corresponding claim here, which then allowed HMRC effectively to seek recovery by way of the petition on behalf of Belgian customs. So I thought I should just remind your lordships of that. But it's helpful because it sets out what the common law position was. My lords, working backwards, as it were, from the points made by my learned friend, standard of review. And let me just, if I may, remind your lordships what was said by the judge in Core Bundle, page A107. And again, we won't get into the debate again, but it was in that paragraph again that Mr. Justice Richards referred to the high degree of deference that he should show to the judge's evaluative conclusions. I've already made my submissions on that, but I won't repeat them. But it is a fact that when he comes to consider the approach, one has a nice symmetry, because he starts by referring to high degree of deference and he ends by referring to high degree of deference. And as I say, I've made my submissions, I won't repeat them. My Lords, then there was a point made that in relation to paragraphs 87 and 88 of the judgment and the so-called material gaps. And I reminded, or rather I respectfully referred your Lordships to what we say in our skeleton argument about that, which I won't, in view of the time, repeat, but it's all set out crisply there at paragraph 45, in paragraph 45. But there are two short points to make. One, if there were gaps, they didn't detract from the import of Ms. Zeglova's evidence, and I won't repeat my submissions, you have them, as to what that evidence means. My learned friend reminded the court of some paragraphs in her witness statement, but not all the ones which I showed your Lordships. And the fact that there may be gaps is, as my Lord Justice Newey observed, something which may be explored at trial, given that at least the evidence gets over an initial hurdle of meaning what I've submitted it meant. And thirdly, the fact of there being gaps or potential gaps should not condemn Mr. Drelle. That would be unfair. Then my learned friend gave an example of Mr. James driving a car. With respect, that's 20 boat lengths away from this case. It's got absolutely, that's one of those analogies which has no relevance at all. My Lords, in relation to the issue raised by my Lord Justice Newey, what we say is this: Mr. Justice Richard's approach to ICC Judge Burton's decision was wrong for the reasons we've given, and therefore it then falls to this court to see whether ICC Judge Burton's decision can be impugned. We've already explained why, and of course your Lordships have all, so far as necessary, have all the powers of the lower court anyway. And as I say, we made our submissions to why she was wrong, and I'm going to come back to the point about whether she looked at everything properly in the round, although there's, your Lordships and my learned friend have canvassed that issue already. Then, in relation to Ms. Zeglova's witness statement, we would respectfully, obviously I accept my Lord Justice Popplewell is asking questions as the bench does and is not expressing a view, so I make that absolutely clear. But what we would do is respectfully adopt the question posed by my Lord to Mr. Phillips in relation to paragraph 83, and indeed looking at that paragraph with all the other paragraphs. What else does it mean? And what it means, looked at fairly and squarely, is that, as is said, Mr. Drelle had no hope of winning the case because GPN was driving it, and predetermined in that sense. It wasn't a trial like one would expect and get in this jurisdiction. And I already made my submissions on that. And my learned friend said that, well, if Ms. Zeglova went into the witness box and wasn't, based on the evidence she's given, and wasn't cross-examined, or she was cross-examined and the judge accepted it, that didn't amount to cogent evidence. That just can't be right, with respect, based on, as I say, a fair reading. And the question posed by my Lord Justice Newey at trial, could there be cogent evidence, providing, I accept, it has to be getting over the initial hurdle, is the correct one. My Lords, then at paragraph 82 of, yes, this was paragraph 82 of Mr. Justice Richard's judgment, and which is a quotation in part from paragraph 73 of Ms. Zeglova's witness statement. And the fact is, again, as I made submissions about this to my Lords yesterday, the fact is, rightly or wrongly, the judge took that as it were, holy writ for the purposes of the appeal, and there's no respondent's notice and no argument in this court that he was wrong to have done that. And that's why I say I'm entitled to rely on that in the context of the other submissions. Again, your Lordships have my submissions on that, so I don't repeat them. Lords, then it is right that in paragraph 70 of the judgment at A96, Mr. Justice Richards drew the distinction between the Maximov propositions, if you will, and a bias case, and recorded the fact rightly in the second sentence, paragraph 70, that we submitted that the Maximov principles didn't determine the approach to be taken in a case of actual bias or partiality, and in this particular case, based on the evidence of Zheglova. And that was, that aspect of it was right, but then it all went awry for reasons we've given. And if your lordships now can look at, or just remind yourselves, if your lordships can bear it, having seen this paragraph 1,001 times already, but at paragraph 131 in ICC Judge Burton's decision of A70, the fact is, and one can look at 118, the fact is what, I think I can shorten matters simply by saying this, what Judge Burton didn't do was to say, I've got all the evidence of Mr. Kulkov, and bearing in mind a la Lady Justice Arden, Berezovsky, and not deciding between exits, but I've got the evidence of Mr. Kulkov. I've got the evidence of Mr. Loff. Pausing there, your lordships have my submission that she didn't properly and fully describe in her judgment the import of his evidence. And I've also got Ms. Zheglova's evidence. Taking that all together, standing back, looking at it, is there a triable issue that this Russian judgment's impeached? She never asked that question. Instead, the judge approached it in this piecemeal way, in that she went through each of Mr. Kulkov's complaints, or the ones she referred to, dismissed each one, said, well, that didn't raise a triable issue, that didn't raise a triable issue. Then she stood back and asked herself, well, in relation to those, that's paragraph 118. Then she dismissed Miss Zheglova's evidence for reasons which we've already seen, we don't need to repeat. And then she, in any event, misdescribed and underplayed, as it were, Mr. Loff's evidence. So it was piecemeal in that sense. And it wasn't helped by the fact, and again, I won't repeat my submission because I gave your lordships the references yesterday, but it wasn't helped by the fact on appeal before his lordship, Mr. Justice Richards, that he began his consideration of the ground by asking whether he should look at it all in the round, but then referred in several instances to, well, this of itself isn't enough. And we gave you those references in relation to Mr. Kulkov and Mr. Loff. So, in a nutshell, Judge Burton didn't do what she should have done, and therefore her decision is wrong in that respect. My lords, then, covered that point already. Yeah. Yes. And again, going back to Maximov, and your lordships have my submissions already on the significance and otherwise of the appeal process in Russia. I'm not going to repeat that. I also made submissions with your lordship's leave this morning in relation to the additional authorities. But the short point is this. If the first decision was the product of bias, then even if it was right and upheld by the appeal court on the law and the facts, it's still impeachable. Fraud unravels all. And it picks up the point with respect, again, Lord Justice Popplewell put in argument to my learned friend, what if I make a decision in favour of my brother, but it happens to be right on the law if someone reads it but doesn't really know what my motivation was? That sort of judgment is impeachable, full stop. It doesn't matter what the reasons are. And that's why we have, for example, Article 6, not a fair trial.
Well, if one's dealing in aphorisms, fraud unravels all means fraud unravels all that is tainted by the fraud.
Correct.
If the appeal hearing is a complete and fresh rehearing, it's not tainted by the fraud, is it?
Well, there are two. Well, it is, and the answer to it is this. What Mr. Drelle was entitled to was a review. Forget whether it's rehearing or, but it's a review, actually, it's a full review because there isn't any new evidence called. But what he was entitled to in that appeal court was a review of an untainted decision. That's the bottom line. He wasn't entitled to a review of a tainted decision. He was entitled to a review
I'm not sure I understand that. If on the first appeal, he was entitled to take the point that the first tribunal, so the first court, had been biased.
Yes, he didn't.
No, but he was entitled to.
Well, he may well have been, but the fact is.
Sorry, your submission was he's entitled to the review on the first appeal of an unbiased court. Well, yeah, the way you get that is by telling the appeal court that the first court was biased.
Yes, but Lord, what I was proposing or seeking to do was to answer the point made by my Lord Justice Popplewell, which, and really the point is this: once one has a judgment which is tainted by fraud, then unless there is the point I made yesterday, unless there is a completely new hearing, de novo effectively, then you're stuck with it. That fraud infects whatever. Even if there was an appeal by Mr. Drelle on the fraud point before the Russian courts, even if on the authority of Appellant and Vidala, it doesn't make a difference anyway, because in Appellant and in Vidala there were appeals. There was an appeal to the Russian court in Appellant, and there was an appeal to the Palermo court in Vidala, and it didn't make any difference.
Those were in relation to frauds practiced on the court, which were operative on appeal.
Well, not just that, my lord, because the point in those cases is the judges are proceeding on the basis that the very issue of fraud was raised before the lower court and the appeal court.
You premised what you were saying, right? Unless there is a completely new hearing de novo.
Yes.
If there is a completely new hearing de novo, does it have to be a new one at first instance, or can it be that exercise be undertaken by the appeal court so to be sufficient? And if only the former, why?
Yes. The logical answer must be, it doesn't matter which court conducts the de novo hearing, providing there is a de novo hearing. And I suppose also providing that there isn't then any prejudice suffered in relation to appeals from that hearing. So there might be an issue if the de novo hearing was conducted by an appeal court, then one was somehow restricted because it was the appeal court. But the fact is that did not happen in this case. There was not a de novo appeal. There was not a repeat hearing that of the nature that took place before the arbitrage court at first instance. But in any event, I come back, and I will repeat one point I made yesterday, and it's this: the judgment that is sought to be, or the judgment which is relied on in this case, is not any judgment other than the judgment we say is impeachable. And that is, it's as simple as that. I mean, you all should have heard that adjective a few times, but it really is as simple as that. Because the question is that judgment impeachable? The reasons we've given, the answer is yes. My lords, then in relation to Russian appeals, can your lordships look at the supplemental bundle, please, at BHE8. This just, sorry, BHE8, yeah, I mentioned this and I just wanted to show you, lordships. So your lordships, the bottom of the page at number 9, experts disagree as to whether the fact that Mr. Drelle didn't complain about violations of his procedural rights, didn't move for a judge recusal or complain to the ECHR is relevant. Mr. Cooklov said he wasn't instructed to answer the question. However, the fact that during court proceedings the litigant didn't invoke breach of the fundamental principle of fair trial and natural justice doesn't mean such breaches weren't committed. Moreover, Mr. Cooklov believes that a claim of violation of this type of procedural rights in a Russian court has practically no prospect of success. And probably that was a reason why Mr. Drelle didn't take such steps. And Mr. Eggerolf, Professor Eggerolf, says, he reiterate my position, if a party doesn't take an active stand in proceedings, doesn't defend its procedural rights, it significantly reduces the likelihood of violations to take place, much less a violation of such a high degree and scale would compromise the principle of fair trial, rules, and natural justice. So,
It's quite a curious thing for an expert witness to have said at the end of to express a view as to why Mr. Drelle didn't take such steps.
well,
Not really for him to say, is it?
no, but I can't. Yeah, but the fact is he didn't. And again, as a matter of English law, the fact that he didn't avail himself of that right does not count against him. And that's no authority on that, which I've already put before your lordships. Then. Then, my lords, and I will finish by it. I have the mental clock is ticking. Yes, in relation to the dispute on disputing a debt on bona fides and substantial grounds, obviously the prior question is there a debt? Well, I mean, it's trite. And there seemed at times in learned friends' submissions with respect that there seemed to be an elision of the summary judgment test, e.g. is there a triable issue as to the impeachability of the Russian judgment, and the separate test, which is if there is a debt in English law, is that debt bona fide and disputed on substantial grounds? They're two entirely separate questions, and that was one of the problems with my learned friend's argument with the various steps that he promulgated at the outset of his submissions when he described the his last submission in relation to a foreign judgment is the question whether there's a bona fide dispute, the judgment can be impeached. But the central point is there a debt in the first place? And I've made my submissions on that, which, with respect, I don't think the learned friend really grappled with. Then, my lords, yes, and then a authorities bundle, please. 8, your lordship's favourite case, in re judgment debtor. And my Lord Justice Snowden referred, I think, to this passage actually in argument with my learned friend. It's page 70, and again, it's 8 lines up from the foot of the page, beginning, of course, apart from statute, the only way of enforcing the judgment of a foreign court was by action, and various defences could be set up to an action of that kind. So that's again, your lordship, but that addresses the point. Then, my lords. Yes, and I think at one point in my learned friend's submissions, in answer, I believe, to a question posed by my Lord Justice Popplewell in relation to foreign judgments, my learned friend said the McGreevy case provided the answer. Well, it doesn't, for the reasons which I gave my lords yesterday. It was not a case concerned with the dicey rules or whether there is a debt, but it was dealing with an entirely different matter. I made my submissions a first time round on those, and I don't need to repeat them. My lords, unless I can assist your lordships further, those are our submissions in reply.
Thank you very much, Mr. Sammy. Just coming back to the revenue rule position, I don't detect from either of you a particular feeling that any more needs to be put in on it. If you disagree with that, then I would say that you could have a short period to put in written submissions if you wanted to, but no.
Well, no, at the moment. I think I will reflect on it in the cold light of day tomorrow. Or do you?
Yes.
Does your lordship want to impose a sort of cut-off?
Yes, I do.
Yeah.
Should anybody want to put in any written submissions, I think they should be with the court by 4 o'clock on Monday.
Very well. Understood.
Speaking entirely for myself, I had thought that we'd earlier reached the point with Mr. Phillips that he had accepted that the word debt in section 267 had to take account of public policy considerations in the form of the revenue rule. And certainly if that's no longer going to be his position, I'd like to know that.
Let's say I'm not encouraging either of you to put in anything further, but you can have until 4 o'clock on Monday, should you wish to, on the revenue debt aspect. Laws.
Well, let me just say this. What my Lord Justice Popplewell said as to the understanding of Maloney Friends submissions was my understanding also. Well, it was, because Maloney Friends' submission was clear. It was a clear answer to a question posed by my Lord.
4 o'clock on Monday, Mr.
Very well.
You won't be surprised to know that we're not going to give judgment here and now, the more so since we've given you till 4 o'clock on Monday to put in written submissions. You will, of course, be supplied with the judgments in due course in advance of their hand down for you to correct our English and typing, but not, of course, to re-argue the case. We would be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are any points on which you can't agree, could we please have brief written submissions, and we would expect to rule on the points in the order that we make. You will have well in mind the importance that is attached to the embargo, and you have helpfully supplied a list of those who should receive the draft judgment. Should you think of anybody else who needs to see the draft before it's handed down, you obviously need to come back to us, and you'll have very much in your thoughts the importance of complying with the embargo. But thank the two of you very much, but also those behind very much for very interesting and helpful submissions.
Thank you very much.